Hi, everyone that's watching this. Thank you so much for joining. This is the Mountford Chambers Regulatory podcast. Today, we're going to be talking about proceedings in the Nursing and Midwifery Council. So we hope to be able to address a number of topics for you this afternoon. The first is, when will a concern be investigated by the NMC? We're then going to have a discussion about interim orders, so the processes that are in place in respect of them, and what types of interim orders can be made, and what factors will play into the orders that are made. We'll then have hopefully a discussion about ways to prepare for a final substantive hearing, and then we will discuss the substantive hearing, how that all works, and possible sanctions that may arise out of a substantive hearing. So first of all, if I could just ask my colleagues to introduce themselves. Silas, perhaps if we start with you.
Yes, thanks very much, Laura. Silas Lee, I'm a tenant at Mountford Chambers. I'm a member of our regulatory team. And I've got a background in regulatory work through working predominantly with the NMC, but now being instructed on behalf of nurses, midwives and other professionals.
Thank
Hi.
you.
Oh,
Rebecca.
sorry. Hi. I'm Rebecca Austin, and I am a legal officer at the Royal College of Nursing. I started with the RCN in about 2013. I've also worked at the General Dental Council in the prosecution teams, but I've been back at the RCN on a permanent basis since about 2018. So generally concentrating on supporting RCN members in fitness to practice proceedings, inquests, DBS, Social Care Wales and CQC.
Thanks very much. And my name is Laura. I'm also a tenant at Mountford Chambers. Been doing regulatory work for about 6 years now. Started off predominantly as a case presenter for the NMC. Again, like Silas, relatively recently have started being instructed by the Royal College of Nursing. So hopefully we can give you the perspective of both in this session today. And so if we can then move on, please, and we're going to talk about when will a concern be investigated by the NMC, and hopefully, Rebecca, you might be able to talk a bit about this, please.
Yeah, sure. So the NMC are essentially there to ensure that nurses and nursing associates have the relevant skills, knowledge and health and character to do the job safely and effectively. They're not there to punish individuals for any wrongdoing, although going through NMC proceedings can feel extremely unpleasant and it's very challenging and at some points distressing to go through the process. Ultimately, the NMC are looking at concerns around nurses' fitness to practice or their entry on the register and whether that's correct or fraudulent. The areas that they look in for fitness to practice are misconduct, competency, health, whether they have cautions or convictions, the appropriate standard of English language, and whether there's been a decision by another regulatory body, such as the DBS, for example. That's quite a wide net of just saying there are all these things that they can look at. And it does sort of cover a very wide spectrum. So it will be clinical errors at work as a nurse, non-clinical errors at work, so things such as dishonesty or inappropriate behaviour, right through to a nurse's personal life, so how they might manage their health, whether they've received a caution or conviction for something completely unrelated to nursing. And it's also worth noting that the NMC can investigate a concern even if the police have closed the case on it, if they feel it's relevant to regulatory action. The NMC full fitness to practice process essentially has 3 stages. The first one being screening, which is preliminary inquiries into a referral that they've received, investigation, which is investigating it, and then if it's referred on to the final stage, which is the fitness to practice committee. The screening stage, where they perform preliminary assessment, comprises it's a 3-stage test, and that's, do they have a written concern that's been brought to their attention in the form of a referral? Do they have evidence of a serious concern? And do they have any evidence of current fitness to practice of the nurse? So this idea of seriousness as a concept is determined through a variety of factors for the NMC. They'll look at, is there a direct risk to public? So if someone's doing something wrong, can we link that a direct risk to them treating patients? But then there's also the factor of reputational damage to the profession, which is what they would call public interest. So essentially, that's what they'll be looking at in screening. And if they feel that all of those things have been met, they will refer it on to an investigation. Generally speaking, if it's a one-off competency or a more minor misconduct issue, or it's been a self-referral for a low-level caution or conviction, the NMC are generally quite happy to have those closed at screening without looking to investigate it any further, provided you've provided enough evidence of good practice. They're quite happy to close it. They're also happy to see if it is a matter for an employer to be looking at. If the employer has dealt with it effectively, then they don't need to look at it any further if there is no longer any risks. So that means that there's a huge possibility for them to close things early on, which is why getting involved with a trade union, contacting the RCN, a trade union, or seeking some sort of legal support is really, really helpful, because they can advise you from experience what types of things it's going to be really helpful to provide to the NMC. So what training you should be looking at, what evidence of that you should be providing, whether or not a reflection is appropriate, giving you some pointers and advice about that. So they can really sort of be very helpful in ensuring that all the relevant information is getting forward to the NMC. But further than that, most trade unions will also have other services available, so counselling, welfare, and also careers advice. So the RCN has all of those, and that's really helpful because it can help you go through those difficult conversations. If you're applying for a job but have NMC proceedings, they can sort of coach you on how to have those difficult conversations with employers, and that's a separate service. But ultimately, what you want to do is get that advice as early as possible. As well as those services, thinking about having advice at the employer stage is also really helpful. So getting your trade union representative, they can seek support from the rest of the RCN trade union legal services to ensure that anything you can do at an early stage to even avoid getting an NMC referral is done. So that's why it's really, really helpful to get in touch as soon as possible, because there's a huge amount of benefit that can be gained from getting in touch with your trade union.
Rebecca, can I ask a question? In terms of when a nurse or a midwife approaches the RCN and says, I've had this paperwork, there might be proceedings against me. How early in your experience does the RCN start engaging with the NMC? Is it before a hearing? Is it straight away? Is there a step that has to happen first?
Straight away. So the main step we have is that any nurse that comes to us and asks for support, they'll be contacting us through RCN Direct. RCN Direct make a referral straight to legal. And from that point, it's going to be employees in the legal services that get in touch with you. So we need a consent form that has to go to the NMC that will allow them to correspond with us and provide us all the information that we need. And for that, we generally need the NMC's reference number. But as soon as you've received papers, we receive papers. At that point, the most important thing then is we can be in correspondence with the NMC, but we can also be advising you from that stage, right, having looked at these papers, these are the types of things that we think are going to be helpful for you to do, for you to obtain, for you to start looking at. So we can start from the first day that you receive those papers, we can start putting into action support for our members.
And do you think, I think having conducted the hearings themselves, this would probably be helpful for me, but from your perspective, do you think it would be helpful upon receiving notice from the NMC to maybe start writing things down about their views on any allegations or what they think happened? Because we know sometimes these processes can be quite drawn out. So I just wondered if that was a bit of advice you might give.
Yeah, I think generally speaking, we ask for them to we'll have an initial phone call with them fairly early on, provided we have got the papers. And during that conversation, we'll be asking a lot of specific questions in relation to it. But we'll also likely to ask for them to fill out a registrants form, which essentially goes through what is it that's happened, what's your response to it. The NMC also quite often send out a context form, but that might not be until a little bit later, depending on what's happening on the case. And again, it's asking them to look at that and respond to those questions, but to us. So the important thing is not to be afraid of giving too much information, because if it's coming to us, we will assess it and decide, actually, don't think we should send this to the NMC straight away, or because you can be, you know, an individual can be in such a panic, they're not sure, I want to tell you everything, but, you know, I don't want to tell the NMC. That's fine. We'll be advising you on what is or isn't appropriate to put forward. We can have those discussions. So giving us information up front and saying, this is how it's happened, particularly if they write it down, if they feel confident to be able to put that in sort of bullet point or prose, this is how I've got to this situation, some sort of statement, we can look at that. And it may be that we say, actually, we don't want to give this to the NMC in its current format, but it's helped me understand what it is I need to know about your case for this time.
So just important for people to remember that the RCN is there for them.
Yeah.
Brilliant. Silas, I don't know if you had anything to discuss about sort of investigating concerns.
I don't think I think you've covered some really helpful questions there, to be honest. And I think one of the things that applies across the board is about that early engagement. From my perspective, and Laura, you probably say something similar, having represented people, particularly at final hearings, you can really tell the difference when a nurse or a midwife has engaged early on with legal representation, because it means there's been so much more time to identify relevant evidence that's going to assist them, or to explore avenues that perhaps where somebody didn't engage at that early stage, there's questions left unanswered. So really, I just absolutely reiterate the importance of what Rebecca said.
Great. Well, Rebecca, unless anything else you have a desire to say at this point, I think we will move on to our second topic. So dealing with interim orders then. So we hope to be able to discuss with you, firstly, what is an interim order? And then secondly, when will an interim order be made? What kind of interim order will be made? So Silas, if you're happy to take the lead on this one, please.
Yeah, sure. Interim orders really are going alongside, run alongside the investigation that Rebecca's just described. And as we're seeing, I think increasingly, investigations can be drawn out for quite lengthy periods now. And it depends on a number of factors. It can include if a case is particularly complex, but even sometimes in relatively straightforward cases, gathering all of the appropriate evidence and having it properly analysed and considered by the NMC, it can take an amount of time that many might think is surprising. And while that investigation is going on, if the NMC thinks there are concerns about a nurse, if that's what their case is, then they might apply for what's called an interim order. What is that? In short, it's an order of restriction on a nurse or midwife. Restriction in what sense? Well, it restricts what you can and cannot do in your practice by imposing conditions, or it can be an interim suspension, which means that you can't practice as a qualified professional at all during the relevant period. So it can come in those two forms. And it's important to note that it isn't the NMC who decides whether or not there will be an interim order. They're the one applying for it, and it might be their view that one should be ordered, but ultimately there is an independent panel who will make the decision as to whether or not that order is granted. So if you're a professional hearing that an application is going to be made for an interim order, it might be conditions, it might be suspension, It's not right just to assume that that's going to be waved through. Often there will be a hearing and submissions can be made by both sides. And again, that early engagement with the union, with the RCN, is really essential, because the interim order will pretty much always arise at the beginning of a case. In terms of that decision-making process, or sort of going a little bit further into what the interim order is, it's assessed on a risk assessment basis, in essence. The NMC's overarching role, they're there to protect the public and to maintain proper standards amongst their professionals. And that includes, as Rebecca has referred to, protecting the public interest, so ensuring that members of the public are confident that the regulated professionals are working to a proper standard. They exist in order to protect the public and the public interest while a case is ongoing. And that's worth noting, because at the interim order stage, a decision on a case hasn't been made yet. So the facts haven't been decided, the truth of an allegation hasn't been decided, but it's a measure that's there to offer protection of any risk while the investigation is being conducted. The panel, they're the ones deciding whether to grant the interim order or not. They will be concerned with those two concepts: patient safety and the reputation of the profession. The analogy sometimes is used of a bail hearing. So in a criminal case, very early on in the case, the question of whether or not that defendant will be granted bail, one of the things that the courts consider is risk of committing further offences, risk of harm to the public. In a regulatory sphere, it's a bit of a different context, but it can be likened the one to the other. And it can be a little bit distressing. I think that's something that we all see in representing or even bringing cases against professionals, because it can feel as though a decision is being made before any of the facts have been aired, before witnesses have been heard from, and before things have been fully investigated. And it can feel that way, but it's worth remembering that panel, the interim order panel, aren't making those final conclusions. They're considering what evidence has been gathered so far, usually just as part of the referral, and what the risks are that come along with that. The hearings themselves are these days generally conducted virtually. The registrant and their representative often have very short notice of the hearing itself. It can be 7 days. And the hearing itself, there'll be usually 3 panel members, one of whom at least will be a registrant, so often a nurse. Sometimes there's more than one nurse on the panel as well. There'll be, as in all hearings, a legal assessor, hearing coordinator, a case presenter for the NMC. There'll be somebody taking a note of proceedings, and there'll be the nurse or midwife. And if they have a representative, then their representative can be there as well. You don't have witnesses at an interim order hearing because the panel isn't concerned with making those final decisions on the facts. So they'll just consider the allegations that have been made on paper at that stage. And one of the important decisions that a nurse or a midwife has to make at interim order stage is whether or not they're going to give evidence. It's an option that the panel will give to a nurse or a midwife, but it's not something that has to be done. And it can be quite helpful at that early stage to take legal advice about whether evidence under oath is given at that stage of proceedings. It can be very early on. And sometimes at interim order stage, you don't have much more to go on than just the basic facts of the referral. And so it can be difficult to respond by giving evidence to the full weight and breadth of an allegation at that stage. And I think the point I wanted to stress was that it's not a tactical decision as such. it's always important to be open with your regulator, and it's not about hiding anything by not giving evidence at an interim order stage. But really, I think it's an acknowledgement from us of the reality of how early the registrant is in the process at that stage. You won't necessarily know the full scope of the investigation. A referral is often made immediately following or shortly following dismissal from the registrant's employer. And it can be quite a distressing and stressful stage of proceedings at that point. And it's not uncommon for professionals, in my experience at least, to be suffering emotionally. And that's something that we all recognise, I think, working in this field. And that's even more the case when potentially them being suspended or being put under quite difficult conditions when that's on the line. So there's definitely a question at that early stage about whether it's the right time to give evidence under oath. If you do, then a note is taken of it, and that evidence can then be relied on as part of the investigation. And in some circumstances, and perhaps in the majority of circumstances, at that emotional early stage, it can be better to rely on a legal representative making submissions on your behalf. It gives more time then to understand the case in full before giving evidence. So in terms of advice and suggestions, that's one thing that's certainly worth considering. Moving on a little bit then, in terms of practicalities, interim orders can be imposed by a panel for up to 18 months. That isn't the maximum length of an interim order, though. It's just that the NMC after that point have to go to the High Court for an extension. We're finding that more and more the High Court are scrutinising those applications. So when interim orders are proposed to be extended beyond that 18-month mark, a High Court judge is going to be looking quite carefully at the NMC's reasons, and they're going to have to give a detailed account of the steps they've taken in their investigation, how timely those steps are, and whether they're making swift and appropriate progress in their investigation. And if they're not, we certainly think that there's going to be a stage, probably quite soon in the High Court, when some of those applications are going to be refused with increased frequency. COVID took a toll, and that's something that regulators are all making reference to. But we're now getting to the point where the sort of COVID reasoning, if I can put it that way, is wearing a little thin, and it's not as good a justification as it once was. And I think regulators are acknowledging that, and I think the courts are seeing that as well.
I wonder, perhaps, Rebecca, I can see you sort of nodding. I think you may have more experience of High Court extensions than certainly than I do. Is that something that you're seeing at the moment?
At the moment, I would say we're seeing a lot of them still coming in, and I think that there's the problem is there's a backlog, and it's working through that backlog for everybody. But yeah, we're still seeing them. But there has definitely been a shift on some cases. I think it's easier to enter into negotiations with the NMC about even the application. They start off asking for 12 months, and I think depending on each case in particular, you can go back to them and say, we understand the need for there to be an interim order, but actually another 12 months is just not acceptable. And you are seeing them agree to actually making applications for 9 months or 6 months. So you can even work with the regulator ahead of time. So I think that sort of shows that they are understanding that the High Court is getting a little bit frustrated with all the requests that they're having for extensions.
And again, I suppose that reiterates the point of, getting legal representation or consulting, otherwise an order may be imposed. Whereas if you had representation, those conversations could happen and move things along, perhaps. Silas, sorry to interject.
No, that's very helpful. And I agree absolutely with Rebecca that it's not always about contesting whether or not an interim order is made. And that's quite an important point. It's about picking your battles. And if you recognise that that some substantive points have been raised as part of that referral, and that there is work to be done, perhaps training needs have been identified, then you can definitely work with the NMC, particularly through the RCN, through a lawyer, to have a discussion about what conditions might be appropriate. And sometimes if you have that engagement, you can avoid an interim suspension because you've had that discussions about how workable certain conditions would be instead of being fully suspended. So it works well, I think, to engage in openly and have a proper practical discussion about how an order is going to work. I was going to talk a little bit about when an order would be made, a little bit in general terms, but we might get into some of the specifics as well. The panel first have to decide whether there is a prima facie case raised by the allegation. And that doesn't mean that they believe the allegation that's been made or they think that it's true. It's just a question of whether a credible concern has been raised. And a common example of this is a registrant has been investigated locally by a health trust. They have found perhaps some gross misconduct and dismissed the individual, and then they've made a referral after that. Generally speaking, that's going to be a prima facie case of a concern of the type that the NMC would investigate. And that's because it's seen to be credible. It comes from an employer. It's been investigated at a local level. There's going to be little argument at the interim order stage about whether or not there's a prima facie case. It can be a little bit different if you've got circumstances where perhaps an unknown person has made a very short complaint to the NMC. The credibility of it is in question and it hasn't been fully investigated at that point. That would be more the circumstances where you'd find there'd be an argument about whether or not there's a prima facie case. But those aren't particularly common circumstances to be in. Once the regulator has cleared that bar, so the panel think, yes, there is a prima facie case, and it is quite a low bar, they then go on to consider whether or not an order is necessary. And that is where the bulk of submissions from both sides tend to focus on. So an order will be imposed by a panel where it's necessary to protect the public or to protect the public interest. So it's those two concepts that we've already discussed a little bit. The public interest, it's rare for an interim order to be made on the grounds of public interest alone. It's much more common that a panel finds that it's for public protection that an order is made. But it's not completely out of the question that an order is made on public interest alone. And one example of that might be where there are no clinical concerns at all about a registrant, no concerns have been raised by their employer or anybody else, but something has happened outside of work. So, for example, they're being charged by the police with a serious criminal offence. It doesn't impact their safety at work at all, but it very well might call into question the confidence that members of the public would have in being treated by a clinician who's been charged with a serious offence of that kind. So those are the sorts of circumstances where it would be public interest alone, but we see that it's much more common that it's a public protection issue that's been raised, so a clinical concern of some kind. In thinking practically, when it comes to risk to the public, the panel will be concerned principally about, firstly, whether there is a risk, and secondly, can that risk be managed? And that's when you get into submissions about conditions. And the NMC has produced a library of sort of stock conditions that can be applied in most cases. They can be adapted, of course, and that's something that can be thought of ahead of time. And what is really helpful is, if you're representing a registrant, is to go through some of those conditions with them and think about what is the risk that's actually being suggested here, and which conditions do we think might meet that risk. And if you break down each sort of category of risk, if I can put it that way, so one of them could be medication errors, but there could be other categories of risk as well. If you break those down into categories and find conditions that meet each risk that's being raised, that can be a really persuasive argument for a panel, and indeed for the NMC, in convincing them that the risk that's presented can be managed while the investigation is ongoing. So again, early engagement and doing that work and that thinking before hearing can be really, really helpful.
Silas, maybe one of the points to say at this stage is that conditions of practice should be workable for nurses and midwives. So Silas was saying earlier, pick your battles. Sometimes it might be an idea to go into the hearing, concede or accept that actually, yes, okay, we understand that there is a prima facie case and order is necessary. And then, as Silas says, perhaps your strongest point is the most workable conditions. I think sometimes nurses and midwives might get a bit of a shock when they are, subject to these requirements that they have to fulfill. But the plan really is so that the nurse can carry on working. So as Silas says, going through and identifying conditions that would be proportionate, conditions that would be suitable, conditions that would allow you to carry on working is a really, really useful exercise to do. And just picking up on a point that Silas made, sorry to interject, there are these stock conditions. And again, sometimes it can be a real shock for a nurse who may find themselves subject to 9 conditions. But it's important to note that quite a few of those conditions are standard conditions, such as reporting any new allegations to the NMC, letting the NMC know if you've changed your employer. So once again, having a lawyer or a union representative with you to explain all of these things to you can hopefully sometimes make the process seem a bit less daunting.
If I could just also point out there, I quite like to talk to registrants about seeing these as actually being supportive. Especially if they've left one workplace and they're looking to go somewhere else. Although that can be challenging to try and do that with interim conditions, if you have a list of requirements and restrictions against your practice where the responsibility is on the individual registrant to comply with them, but you can provide them to an employer, and it is stuff like ensuring that they have a monthly meeting to talk through all areas of their practice. Now, essentially, you're supposed to have monthly supervisions, but in reality, that doesn't always happen, and particularly in healthcare where people are extremely busy. But you have a list of things that says, I have to, and I'm being monitored. So I want to have this. Actually, it's a very supportive way of finding an employer from the outset that knows what they've got to do. And so you found a supportive employer. Often they can be similar to what you would expect for a preceptorship if it's a brand new nurse that hasn't quite met the competencies. And I say that, the conditions that are imposed that are there are actually to support you back into practice rather than hinder you. It can feel like a hindrance and a restriction because they are, but actually they are designed to support someone back into safe, effective practice.
Yeah, I absolutely agree with that. And I think that sort of connected to that is that we see sometimes interim orders working well for registrants and sometimes them not. And about understanding why those situations occur. And I think when interim orders work well, it's when a nurse is fully open with their employer and engages really well with them on the conditions, and then can bring back to the NMC evidence. So, for example, if one of your conditions is that an employer has to write a report about your practice, for example, in administering medications or in administering particular care that there was previously a concern about, if you've obtained that report and bring it back to the NMC, that can be then a persuasive argument for either removing conditions at a later stage, changing them, or even at the end of a case when sanction is considered. When conditions don't go well, tend to be when a professional sticks their head in the sand a little bit, doesn't fully acknowledge them, and particularly some registrants get into trouble when those conditions aren't fully or openly declared when applications for new work are made. And I think we all understand that the imposition of those conditions can be really onerous, and it can make it difficult to find employment. And a lot of nurses that I've met and spoken to have described just how many applications they put in and just how many rejections they've got. And the more onerous your conditions are, the harder it becomes. But also the more important it is to be open and to comply with them as well. And the NMC certainly doesn't have a shortage of referrals that are made where the allegation is that a nurse has been on conditions and not properly declared them to their employer. And that's when you get into dishonesty territory. And things can become really difficult then for your reinstatement and going back to work after the NMC case is finished. I know Rebecca's already mentioned the help that the RCN can give with careers, and I'm sure that help will cover conditions and how they're declared. Is there some assistance with that as well?
Yeah, so they'll help you. Basically, you can get assistance on how to have those difficult conversations. So framing that situation. And I would also advise and speak to registrants about, yes, it's a hurdle to overcome, but actually you've got to see the plus point of it, that people who haven't gone through fitness to practice or don't have their regulator looking at them aren't necessarily aware of how diligent, and have that sort of light bulb moment of being like, yeah, I've got to really be on top of my practice. Someone that's going through it, that is fully engaged in it, is going to be ensuring that everything that they're doing is correct and done really well, which is what is going to make them a better nurse. So it's about having that conversation of, I know I'm going through this, I'm being open and honest, but you know that I'm going to be acting and practicing the best possible version of myself because I have a regulator looking at what I'm doing. So I'm not going to make mistakes. And it's framing it in that positive way. And that's definitely something the career service can help with, about how you're going to approach things, difficult conversations, interview technique, and ensuring that you're getting it down on your CV or application form.
Yeah, absolutely. And I think when we talk about the workability of conditions, I mean, one of the things is, in terms of engaging with an employer, whether it's your current employer or a prospective employer, it's really helpful for you to know and for the NMC to know, are those conditions actually going to be workable in the department that you're currently in? And one of the snags can often be that if a panel think and find that you need to be supervised as part of your work, and if that supervision is quite onerous, some departments simply don't have the resources to offer that kind of level of supervision, whereas other departments might. And so sometimes there's a question before an interim order hearing as to, can we get a letter from an employer? Can there be a conversation with the line manager? If we were going to propose to a panel conditions of this type, would that be something that you could support? And if it isn't, sometimes employers can be really helpful with finding transfers to other departments and things like that. But again, it's about having those conversations ideally before you're at a hearing, so that you have something to present that you can say, here's the evidence, here's how we know that this is going to work, and you can be confident in making an order of this type. Yeah, I think that pretty much does it for me on interim orders. It just, in terms of a brief summary, they're there to manage the risk, whether that's to the public or to the public interest. They can only be imposed if the order is necessary to manage that risk. And really, we're concerned with the practicalities and gathering hard evidence that an order is going to be workable. It meets the risk that's actually being suggested. And those are the sorts of things that you can put before a panel to persuade them, for example, that a nurse or midwife shouldn't be suspended while an investigation is going on. Thanks, Laura.
Great, thank you so much, Silas. That's really, really useful. And thank you, Rebecca, as well. It's always so interesting, I think, for us to hear from the preparation side and from the providing assistance to nurses and midwives. Sometimes we only get to see the final hearings or simply just the interim order hearing. So it's great to know that there's so much support that is provided for people going through this process. And that's a really important point, I think, to reiterate. So that neatly takes us on to final hearings then. And Rebecca, again, I wonder if you could help with what top tips perhaps for registrants to be undertaking in the lead up, how they can work with their representative to try and get the best possible outcome.
Yeah, so essentially what we're doing is looking to preparing the final case. The NMC should provide all the information and evidence that they've collated and that they've got, and then we need to review that and make sure that we're equipped with an appropriate response. So it's about preparing essentially a bundle of evidence and really ensuring that we understand the case. We'll obviously then be instructing advocates to actually do the advocacy for the final hearing. And it's making sure that the registrant is on board and engaged with their case, because our role is to advise and support. We can review the information you provide us. We can also, to a certain extent, seek further information and advise you on the legal ramifications. But ultimately, it's the registrant's case at the end of the day. I will not have been in the room when the incident occurred or however the things happened. So unless I'm provided information about it from the registrant, I don't know and I can't help. There's not a defence book I can pull off the wall and say, oh, we'll use the Richardson defence. It really comes down to how much the registrant wants to engage with their legal representatives, listen to what they have to say and go away and do the work or provide the information, because we can only go on what you give us. And so we try as hard as possible to provide as many tools to be able to assist, and we're always available to answer questions. But it is about looking at it from a breakdown of the panel are going to look at the facts, they're going to side on the charges. Is there any evidence that we've got or we need to obtain in our favour in relation to whether or not they did happen? It's often normal not to have other witnesses available to us to go and get. Sometimes we do, and sometimes they're available and we need to know who they are to get witness statements from them. Other times there just isn't, because not everything happens in a perfect world where there are witnesses that were standing there watching everything you were doing. And so that's fine. But it's about then what evidence is there? Is there information that an employer would have that we need to try and obtain or ask the NMC to obtain? But beyond that, we're also always, no matter what someone's response to the charges is, we're always going to looking at remediation and fitness to practice. Even if you are absolutely denying a charge, we have to look at, are there elements that you can take responsibility for? And or we've got to look at current fitness to practice and whether or not you're accepting them. Is there any training that you can do? Even if you're denying the concerns, if you've got a concern about medication administration, one of the best things you can do is make sure you've done training in medication administration and competency. Have a new competency assessment, even if you're denying what happened, because we get to say we deny, but even if you were to find it to be true, it can't be a problem now, because panels will also be concerned with your current impairment and whether or not you remain impaired as a result of the charges. So it's going to be about setting a lot of homework for the registrant. We want up-to-date testimonial letters, and we've got guidance documents about what should be in the testimonial letters. We've got guidance documents on what should be in a reflection. We can also talk to you specifically about what could be in there. Also guidance documents on training, but it's about getting engaged early on and trying to get that. It's often we will have been doing these things at the investigation stage, and it's about looking at, can we do an updated version of this now? Can we get some updated issues, or, you know, the case examiners said this in their determination, so we want a fresh reflection that looks at that. Talk to us about whether there are health issues involved. Should we be getting GP reports, medical evidence, etc.? But the most important thing is that you are engaged with your legal representatives, that you're talking to them about what's happened. And that's where I find it's really helpful for you to write down what it is that you want to get across. So we'll often be provided with a case management form. Well, we'll always be provided with a case management form by the NMC if it goes to a substantive hearing. And it's at that point that the RCN will be instructing a barrister. And we will look to have a conference, either on the phone or via Teams or in person. And prior to that conference, it is essential that as a registrant, they've reviewed their case, that they've actually read the documents that have come from the NMC, that they know who is going to be witnesses providing evidence on behalf of the NMC, and that they've gone through it to say what they think should and shouldn't happen. Relying on your legal representatives to do that is dangerous, because we weren't there. So although we might be able to say, well, I can see there's an inconsistency between the referral form and this final statement, that's all I can see, because I wasn't there and I didn't know what was happening. So it's really important that write down a list of questions that you may have about it. We're not expecting you to know the process at all. That's what we're here for. But you're also going to be the person that has been medically trained, that will be able to answer, this is what a nurse should or shouldn't do. If we have any further questions about that, we can look at getting an expert report, but it's down to the registrant saying, this is what's happened, this is what I would normally do. So it's just really about making sure there's a lot of collaboration and communication, and being prepared for when you have those opportunities to talk to your legal representative, not just turning up without the documents, not knowing where they are, not having read them. Turn up fully equipped, because at the end of the day, this is your case about your registration, and we want to do absolutely everything we can, but we are there to advise you on what is best. So I think that's probably one of the most important things, because only when you've given us all that information can we look at, do we need to go back to the NMC for things like disclosure? We're not expecting you to know how to do that, or necessarily that you can do that, but until we're able to have really open discussions where everybody is knowledgeable about the papers, are we going to know that's something that we should be doing? Or is there any other legal arguments that we should be making based on information that you've then provided us with? So I think yeah, and then everything else that does come down to sort of the legal side of things, redactions, etc., looking at whether or not it should be virtual or physical, a lot of that can come down to your legal representatives advising you on those types of things. And that is what we're there to do. We do this every day, but it really does take a huge amount of collaboration between everyone working together and communicating to get sort of the best that you can in preparation for a final hearing.
Brilliant. Thank you so much, Rebecca. And if I can just talk a little bit further about the final hearings then, just some initial points, and apologies, some of this might be repetitive, but these are such important points that I think they are worthy of repetition. The first is the NMC's aim is to keep the public safe. And this goes for the interim orders, this goes for the final substantive hearings. It's not there to punish or try and embarrass registrants. And as somebody who has presented cases for a number of years, I completely endorse that. My experience has always been trying to find out what happened, and trying to keep the public safe. It's not there, it's not a criminal court, and it's not something that's there to try and make you feel bad or criminalized. And so it's important to just remember what the purpose of all of these proceedings is when you go into it. The second point is it's never too late to start engaging. I know that we've been talking about engaging from the outset, and of course that's ideal. But as Silas said, sometimes people do bury their heads in the sand. But it isn't, I don't think, ever too late to say, oh, okay, I'm ready to face up to this now. Now is a point at which I think I do need help, and hopefully more often than not, the help will be there. The next thing I wanted to say is that there's no charge that will shock or surprise your legal team. these often feel like very, very personal matters, particularly we see a number of cases where there have been perhaps personality clashes in trusts that can make these hearings feel as though you're being targeted. And I certainly know that I've experienced registrants feeling like that. But please don't be embarrassed. As Rebecca said, we need to know the information. Nothing shocks us. In the same way that I imagine you as a nurse or a midwife, I would probably feel very embarrassed if I had some ailment, but in your job, nothing would shock you. So please be as open as possible. Going back to something that Silas said about interim order hearings and picking battles, and Rebecca's touched on this as well, you might go into a substantive hearing, there might be 10 charges, you might accept 5 of them. And if you do accept them, it's great to get that on the record. As Rebecca says, get involved with training, remediating, reflecting on those. It's not a fight to the death. You can accept some things, not accept other things. And quite often accepting the things that you have done wrong when it comes to the final sanction and current impairment, which Rebecca's touched upon, it's really helpful actually to say, this did happen, give your reasons as to why it happened. If I can then just briefly talk about what actually happens at a final hearing. So we've heard previously that more often than not, the NMC cases are still being heard virtually in the post-COVID world. More and more are coming back to being in person, but I would say the majority of them, in my experience, are still being held virtually. So in fact, I suppose the first thing to do if you are going to be attending a virtual hearing is make sure you have a way to attend the virtual hearing. Make sure you're familiar with your phone or your tablet or your laptop. Do a test of the software in advance. Make sure that you can hear everybody. Maybe try and, if you're on a mobile phone, which I should say is perfectly fine. We have any number of registrants attending simply on a mobile phone. Make sure you're comfortable and you're able to access it and you're able to work it. The final hearing takes place in 3 stages. The first is the facts. The second is either if it's a misconduct case, it will be dealing with misconduct and then moving on to current impairment, or if it's a lack of competency case, that will be dealt with at the misconduct stage instead. And then moving on to sanction finally. Dealing with the fact stage then, as we've reiterated, this is where it really comes into its own if you have been engaging since the start. The best advice that I can give is know the bundles well. It's always difficult when you get to the final hearing and you say to your representative, I know that there is a document that shows that this isn't true, but I can't find it and I don't know where it is. And perhaps the NMC never gave it to us. Quite often the NMC might need help with finding documents. Of course, they get the referral and they hear it from the referrer's side. But again, reiterating what Rebecca was saying, if you think there are further documents that exist that will help you, let your representative know, and the NMC will be more than happy, in fact, would actively encourage that so that they can go and find that material to make sure that this final hearing is as fair as possible. So know those bundles really, really well. Know the witness statement bundle really, really well. I think that's a very crucial point. And again, think about it in advance. I said back at the beginning, when you first receive the paperwork from the NMC, which may have been a year and a half, even 2 years before the final hearing, start to jot down notes. Quite often you'll find that you're dealing with facts in this final hearing that happened such a long time ago. And if you yourself take on the responsibility of, okay, it was 3 months ago now that I've received the referral, but it's kind of fresh in my mind, rather than waiting sort of until the week before the hearing to suddenly try and think, oh gosh, what did happen on that night shift? That's really important. It helps your lawyers prepare the case, and it helps you to remember what happened. It helps you to challenge the evidence against you. Maybe not even challenge, maybe sometimes it helps you to explain your actions and what happened. Moving on then to the second stage, which is the misconduct or lack of competence and current impairment. So misconduct is an odd word, and I think that the other two lawyers on the call will laugh at me because it's quite a difficult word to define. It tends to mean something that another practitioner would find deplorable, or something that falls well below the standards that would be expected. So it is actually quite a high threshold, and sometimes at this stage panels may well have found facts proven, but say actually they don't amount to misconduct. You might be able to say in your evidence to the panel or your lawyer on your behalf, this happened, but actually it was a really, really busy ward. It was the middle of COVID. It was March 2020. I don't really know what more I could have done. And the panel might think, that's actually quite fair enough, that it happened, but does it really reach the high threshold that this was deplorable or fell way below the standards? In fact, no, it doesn't. So engaging again at every point of the proceedings helps with every future stage. It's almost like a Jenga game being built up with blocks. And if you can remove blocks at any given point, that can be really helpful. Lack of competence is essentially not meeting the standards that are required. It doesn't go as high as misconduct. It might have not been a deliberate action. It might be not getting up to the standards required for a probationary period or a personal development plan. And then the next part of that stage is dealing with current impairment. And you've heard us use that word quite a lot. Current impairment just means, are you fit to practice at the moment? It's not the purpose of the NMC, as I say, to go back and punish you. It's whether you're safe at this current time. And once again, going back to how important it is, even if you deny charges, as Rebecca says, engage with training, engage with reflective pieces, undertake courses, because when you get to this stage, you might be able to say to a panel, I accept in 2021 I made that mistake, but look at what I've done. I've gone away. I've worked on all of these things. I'm currently fit to practice. And as Silas said, a conditions of practice order can sometimes be helpful. And I think Rebecca iterated that as well. It can be helpful for you if you are on a conditions of practice for the whole of the investigation and you work safely on that conditions of practice. Again, going back to the building blocks, you might be knocking some of those conditions away because your practice is getting better and better. That's a great way to show I've been working for the last 2 years, there's been no further issues. And then finally, sanction. And again, I would mention the NMC's guidance on this. The NMC website is great in terms of the guidance that it offers. It has a lot of information about what registrants can expect from hearings, and it deals with all of the sanctions that are available. Different sanctions are available depending on whether it's a competency case or whether it's a misconduct case. And so just to outline what these sanctions are, the panel can take no further action. They can impose a caution order of between 1 and 5 years. They can impose a conditions of practice order for up to 3 years, suspension order for up to 12 years, and a striking off order. And they have all of the factors that are considered online for people to explore in their own time. Of course, again, I would say it's very useful to have legal representation at this stage of the proceedings. Sometimes it can get very overwhelming in the hearings. People can become very emotional. And so having written documents you can submit to the panel or a lawyer that can say what you want to say on your behalf can be really, really helpful. That they'll consider anything you want to put before the panel. Panels are very, very good at listening to what registrants want to say. At the end of the day, it is their hearing, it's considering their practice. If you want them to know something, then the panel will listen to that and they will take everything into account. I don't know if anybody else wants to jump in on final hearings.
Just a couple of points from me, if I may. One of them is that obviously we've talked about having legal representation at these hearings, and a lot of people do, some people don't. It doesn't mean that you don't get to say anything. there are multiple opportunities for panels to hear directly from a registrant, whether that is them giving evidence about the facts, so what happened in a certain allegation, or at any other stage. And in my experience, the NMC and panels work quite hard actually to make sure that registrants understand proceedings well, fully, and also that they're engaged, that their views are properly understood and responded to. And the second point I was going to make is that I think a lot of people don't necessarily have the clearest idea about what a final hearing looks like. How does it work? What's the atmosphere like? It's not a battleground, that's for sure. And it can be very easy to be stressed and very nervous going into one of those hearings, and that's natural. But one of the core NMC values is kindness. Certainly in my experience, whether it's panels, legal representatives, legal assessors, even dealing with incredibly serious allegations and cases where nurses have been struck off the register, parties have always acted with kindness and taken account of a registrant's views throughout. So that's the expectation. In my experience, it's the norm as well. And it isn't the stereotypical contentious court hearing that you might see on TV. And I think just knowing that going in perhaps just helps settle nerves a little bit.
Yeah, absolutely. Again, I would say that my experience as well, it's not meant to be a harrowing experience. It's a necessary part of the regulatory process. But I tend to find everybody acts with compassion and, as you say, kindness. So I think it is really important to point that out. And again, really important to note how much registrants can engage in the final hearing, as you've said, giving evidence, talking about their own reflection, talking about their thoughts. And once again, as you say, panels are very, very accommodating. I've had cases where we've made adjustments for people taking regular breaks. People don't have their camera off, perhaps if it's too emotional or too difficult. And as I say, the whole process is about that nurse or that midwife, and that's really what everybody is trying to focus on, to make sure that they have the fairest hearing possible. Rebecca, I don't know if there was anything, any final comments you wanted to make at all.
I think I would just say, touching on what you've just said then, it is about the registrant, the other aspect of the support that we can offer. Looking towards a substantive hearing, each individual nurse might have their own set of circumstances. And the other thing to consider is they may not want to go through a substantive hearing. So that's another option that we can give advice on. So there are a couple of alternative disposals available, and it's about really getting the appropriate advice as to whether or not that's right for you, and that's right for your future. But there are things like agreed removal that will allow you to come off the register. And that is sort of a final declaration of I have these fitness to practice proceedings and I'm not going to a final hearing. I want to come off because I've reached the end of this stage of nursing as my chosen career for whatever reason. And it's about putting in an application that's more likely to succeed based on what we think the NMC want to see. It's also looking at whether or not there can be an agreement via consensual panel determination that takes place beforehand, which we could probably do a whole other podcast on, but is just essentially agreeing on an appropriate sanction for that person without the need to go to a substantive hearing. But it's also really getting the advice about what the potential risks are if you don't engage as well. So what's more likely to happen as to whether it goes to a hearing or a meeting, etc. There are other ways. Each individual may come to us and say, do you know what, I've got these reasons and this is why I don't want to go through with it. And actually it may be that after a conversation with their legal representative, they find that knowing a bit more about the process, what's expected, it's not as daunting or as scary. And then they feel a lot more confident to be able to go through it. Or they feel, no, you've explained to me what the alternatives are. And for my particular set of circumstances, I would like to remove myself from the register via application where possible. So there are alternatives, but it's just as important to seek advice about them as well, because with some of them, it's very difficult to turn around or change your mind once you've gone through that. And if you haven't had all the appropriate advice, then you might not know what you're walking into. But generally, absolutely, panels at final hearings they're not there to get rid of nurses. They're not there to catch people out. They want to just have everything explained to them. They're totally independent from the NMC, and they want to come to a decision based on the evidence that they're able to interrogate and everything you put forward. So it is about being as prepared as possible.
Brilliant. Well, I think that's a very good note to end on. So thank you so much to everyone that's listened to this. Thank you so much, Silas, and thank you so much, Rebecca. Hopefully this was useful. We have got quite a lot of regulatory related content on the Mountford Chambers website. So please have a peruse if you found this interesting. And thank you again for listening.